Good morning, all, and today's video is about how almost anyone who is autistic could prevail in a Title II American with Disabilities Act case for money damages against the Florida state court system. I know this from firsthand personal experience of my own cases, and I know I can do this. And here's why. The Florida state court system, the circuit courts in Florida and their ADA coordinators, that's American with Disability Act coordinators, and one of the most egregious statements to come out of that report was that the court staff and the ADA coordinators were saying, well, I don't think there's any ADA problem here because, well, our court hasn't seen any disabled people. I mean, how arrogant, how intentional is that kind of discrimination? Because we know that in 1990, when the American with Disabilities Act became effective, in the findings, in the congressional findings, there were at least 42 million Americans with disabilities. So what really can be said about that attitudinal barrier that existed then and continues to exist in the Florida state court system is that the Florida state court system is denying access to the court to individuals with disabilities, and then they're patting themselves on the back about they haven't seen any disabled people because of it. So, logical reasoning here. There's difference between autistic logical reasoning and neurotypical social reasoning. The neurotypical social reasoning is, we haven't seen any disabled people here, so we're not in violation of Title II of the American with Disabilities Act. Well, the autistic logical reasoning is that it's kind of a circular argument. If you're saying that if you're denying access to individuals with disabilities to your court system because, one, your rules of procedure violate Title II of the ADA in numerous respects, the way you conduct face-to-face court proceedings and your rules for reading facial expressions and body language and determining who's telling the truth and who's not violate Title II of the Americans with Disabilities Act, because you're not training your court staff and judges and lawyers in mandatory Title II American with Disabilities Act, continuing legal education and judicial education, and most specifically, you are not training them in autism spectrum disorders. Well, then your statement that, well, you haven't seen any disabled people, so you're not violating Title II of the ADA, is actually a confession that you are violating Title II of the ADA. Now, let's look at myself and being autistic. And so the first thing we're going to look at is this faulty implementation of Title II of the American with Disabilities Act in the Florida courts and lying circuit judges. So we're going to start with the Honorable Monica Brasington. The Honorable Monica Brasington held a hearing on February 26, 2018 in the Alachua County Civil Justice Center, Gainesville, Florida. Let's look at the faulty ADA implementation in the Florida courts and the lying circuit judge. Lying, flat out lying, to take away real property from an autistic person and individuals with disabilities. Honorable Monica Brasington. So, in the middle of this hearing, the court, you have a history of filing very lengthy documents 2 minutes before a hearing starts. Note for the record that this hearing is set at 11:30 today. The document that you handed me was filed at 10:47 this morning, and what we note from this is that the judge could not possibly have read that motion. It was a motion to vacate. Your Honor, I have one more document. That is the accommodations I am certified for by the California Bar Examiners. If I don't have them, I do file things late. If I do have them, I can participate. So here the circuit judge is clearly not recognizing the full participation and equality of opportunity mandates of Title II of the ADA. The court, Ms. De Petrano, me, in the essential requirements of any lawyer or anybody else. The court, Ms. De Petrano, me, in a court of law, these are my accommodations there. The court, if you could not interrupt me, I would like to ask you, because here comes the confess all. Here comes the confess all by Monica Brasington. She is violating Title II of the Americans with Disabilities Act. The court, if you could not interrupt me, I would like to ask you, because I've informed you a number of times that Vanessa Sagar is our disability coordinator. And I've given her information so that you could contact her directly. Have you made any specific request for a specific accommodation? And so here the judge hasn't even reviewed my ADA request for accommodations, obviously, or she would know what I requested. Ms. De Petrano, every time I contact Ms. Sagar, she just ignores me or says that I'm being provided what I'm being provided with. The court, what I could tell you is that here's the lie. Here comes the lie by a Florida circuit judge. What I could tell you is that every specific accommodation you have asked me for, I have provided. I have a real court reporter here at every court proceeding. I serve you and my assistant to come up with a special. Mr. Petrano, as an accommodation, you needed extra time. The court, excuse me? Me, as an accommodation, the court, excuse me? Me, I needed extra time. I'm never getting that. The court, excuse me. If you could not speak over me, I would greatly appreciate it. And so, here is a circuit judge, dishonest judicial officer of the Florida State Courts. On the face of this transcript, she is lying to an autistic person that she has responded to, granted or denied, every single reasonable accommodation requested, but that's a lie. How do we know? We know the Honorable Circuit Judge, Florida Circuit Judge Monica Brasington, lied on the face of the transcript and was dishonest, because here's the cases that the ADA reasonable accommodations were requested for. 3 cases assigned to her. The case numbers of the cases assigned to her, starting at the outset of the cases and throughout the case. One was for CART real-time plus a copy of the transcript, the CART real-time transcript for memory loss. Another was for all documents, papers, pleading, notices, everything being used in the case to be in a format that did not trigger sensory overload and autistic meltdown so I could see it. Another was electronic filing. Another was an across-the-board extra time reasonable modification of all rules for both writing and spoken. Another one was for a disability service pony. And the last one was for an autism language interpreter and translator. And right here we have a former NASA doctor informing Monica Brasington that because of my being autistic, I am unable to type and produce usable material. Written pathways to self-produced language are, for me, not comprehensible, not well structured. So, you can go into the docket of all 3 of those cases. The last 2 cases, Monica Brasington, with her lie, her flat-out lie on that transcript that she responded to every ADA accommodation request, and provided it. In all three of these cases, in the last two, we were put on Florida's autism segregation vexatious list. You can look at this, and you can look at the docket. You can look at Brasington's orders. You can look at what she says in that transcript on the face of the transcript, and you will find that she never responded at all whatsoever to either grant or deny. She just ignored, intentionally, willfully ignored my ADA request for blanket extra time for all spoken and written activities in the court. She ignored my request for a CART real-time transcript, and she ignored my request for an autism language interpreter translator. So when you look at the ADA request in the docket of her cases, and then you look at what she says on the face of the transcript, it's really clear she flat out lied and was a dishonest Florida Circuit Judge. Now, what else does that mean? Well, okay, Florida Supreme Court, if you want to be my bar examiners, I understand I cannot cite the following case for precedent because you depublished it to violate Title II of the American with Disabilities Act because you didn't want any disabled people in the Florida courts to know what their rights were. And you didn't want the intermediate Florida District Courts of Appeals to follow this case. That's the intent and motivation why you depublished it. I understand, and I'm not going to violate your rules and cite it for precedent. But if I sue the 8th Judicial Circuit public entity in a federal court, if I sue the Florida Supreme Court public entity in a federal court, I can use this as a hearsay exception under the federal rules of evidence as a declaration against interest of Monica Brasington, Florida Circuit Judge, and against the 8th Judicial Circuit and Florida Supreme Court public entities. Because here's what your case confessed all and admitted. You admitted this when you released this opinion, whether or not it can be cited as precedent. This is the Florida Supreme Court's confessal in Gabriel v. State. Gabriel filed a petition for writ of mandamus in the Florida Supreme Court asking the court to compel the Intermediate Florida 4th District Court of Appeal to accept his pleadings filed in Braille and correspond with him in Braille formatted document. Now, I've been told by the Florida Supreme Court Clerk John Tomasino that when I have asked for jurisdiction and review in the Florida Supreme Court, oh no, there's no jurisdiction in the Florida Supreme Court under the Florida Constitution and Florida case law to review your issue of failure to reasonably accommodate your disability being autistic. I've been told this by John Tomasino, Clerk of Court. Well, it cannot be true. So John Tomasino is also a liar. And you got to understand that Honorable Monica Brasington and John Tomasino are neurotypicals. So, in fact, John Tomasino, Clerk of the Florida Supreme Court, is telling me that the Florida Supreme Court had no jurisdiction over my failure to accommodate issues in my 3 cases before Honorable Monica Brasington was a lie, because here's the declaration against interest of Mr. Tomasino, of Monica Brasington, and the Florida Supreme Court itself. The Florida Supreme Court says, to be entitled to writ of mandamus, the petitioner must have a clear legal right to the requested relief. The respondent must have an indisputable legal duty to perform the requested action, and the petitioner must have no other adequate remedy available. And so they hold that this disabled guy asking for Braille format against the Florida 4th District Court of Appeal Intermediate Appellate Court was indeed entitled to his mandamus relief. They say this because the due process clause, remember that, due process, of the 14th Amendment and 6th Amendment to the United States Constitution grant this disabled petitioner a clear right of access to the courts, and they cite Tennessee v. Lane. Second, the Florida Supreme Court says the Florida District Intermediate Court of Appeal has an indisputable legal duty to provide accommodations, this is under Title II of the ADA, to the petitioner. And then they cite Florida Rule of Judicial Administration 2.540A to say that he gets reasonable accommodations at the court's expense. And then they go on to cite, actually, this is sort of like wacky. This is where the Florida Supreme Court shows that its lack of Title II ADA training of all the judges, including themselves, mandatory Title II ADA training, causes them to cite a Title III ADA provision when they're a Title II public entity. But nevertheless, they do, and they talk about discrimination. And the petitioner has no other remedy available than to petition the Florida Supreme Court for relief. The court says the Florida Supreme Court has jurisdiction. So this contradicts Florida Supreme Court John Tomasino, who refused me jurisdiction before it ever went to the judges in my 3 cases that I filmed the numbers here when I tried to ask for jurisdiction in the Florida Supreme Court to get a similar order to order Monica Brasington, Circuit Judge, and the Florida First District Court of Appeal to accommodate my being autistic. And this is signed by the Florida Supreme Court justices and the predecessor clerk of the Florida Supreme Court to John Tomasino. I got nothing. I got blank pieces of paper from Monica Brasington. She says, and here's the ADA violation, the big one. She says, I just give everything to the ADA coordinator. And I give everything to the ADA coordinator, Vanessa Sagar. Well, what is Vanessa Sagar? Is she an elected or appointed judge in the state of Florida? As a judge is defined under the Florida Constitution? No, she's not a judge. Well, what is she? She's a human resources manager. And human resources is tasked to cut the fat out of Florida's court budgets. So you got a conflict of interest by assigning Florida's ADA coordinators who are human resource managers. But it's worse than that. First of all, there's no autism spectrum training going on in the Florida state courts. And I got a public records request back from the Florida Supreme Court that said no judges were getting any autism spectrum training as late as 2021. So for all these 3 cases with Monica Brasington, Circuit Judge, she had 0 autism spectrum educational training. And yet here she is deciding all sorts of stuff about autism, about my being autistic. Well, what was her basis in knowledge to be just saying these things and making them up out of the air? You know, you can't not have confidence in a court system that has no disability training, no autism training. They're failing autism. They're fabricating nonsense facts that don't exist. And they're using a neurotypical inference-based language to find intents and motivations in the autistic person and internal emotions and feelings that are not there and that they're misunderstanding and misreading. You can have no confidence in the integrity of a court system like that. None. How do I know that if I bring a Title II American with Disabilities Act violation case against the public entities, 8th Judicial Circuit of Florida, Florida Supreme Court, for violating Title II of the ADA by implementing its enforcement in a wrong, flawed, and defective manner in the Florida state court system, and for failing to give mandatory Title II ADA educational training and autism spectrum educational training to every single Florida judge at every single level, how do I know I can win on summary judgment? For the simple reason that, as Monica Brasington said on the face of her transcript, I just take everything and give it to the ADA coordinator, who in that case was Vanessa Sagar, who is not an elected or appointed judge. So she does not adjudicate cases. She is not the person that asks the questions and directs the way the opposing lawyer asks the questions. The ADA coordinator cannot walk in there, put on the black robes, and sit in the judge's seat high up on the bench and do the duties of the judge. That's how we know that I can get a summary judgment in my favor against the Florida state court system. Why? Because I'm autistic. Because the flaw and the defect that violates Title II of the ADA in the way the Florida courts implemented Title II of the ADA in the court system is, they just don't want to train the judges. They don't want to spend the money doing that. So they just said, the ADA coordinator, give her everything, judges. All you judges, give your ADA coordinator everything, and she will provide the accommodations. Well, when a person in the court is a litigant, like me, and is autistic, it's the judge who has to provide some of the accommodations, not the ADA coordinator, because the ADA coordinator is not a judge. And so that violates Title II of the ADA. And why do we know that? Any competent Title II ADA educational training, this can be found on Facebook, on the Autism discussion page, would have a discussion about the communicative social interaction between the judge and the autistic litigant. That is an accommodation the judge has to provide him or herself. It's called imperative versus declarative language. The judge needs mandatory autism spectrum educational training, every single Florida judge, because they have to alter the way in which they communicate when the litigant is autistic. The greatest tool for reducing performance anxiety in an autistic person is changing the way you communicate with the autistic person. An autism discussion page makes it really clear it's not just talking about children with autism if you read the post. It's talking about adults too. And so there's an impact that neurotypical language has on increasing engagement with autistic people. There's an important difference between imperative language and declarative language. Imperative language is any statement that is meant to elicit a specific response. These include questions, directives, instructions, prompts, and other instructing, questioning type statements. They are meant to direct and control. Imperative language tends to put people on the spot, requires a specific answer, and causes social performance anxiety in people who have difficulty interacting, such as autistic people. Direct communication to act requires the person to rapidly process what is said, what is meant, how to respond, and to execute the response. This rapid processing and executing creates strong anxiety in some autistic people. What did they say? What did they mean? How do I respond? Will it be right? All creating anxiety, further inhibiting their already compromised communication. And this is also because, refer to other autism discussion page posts on delayed processing in autistic people. Autistic people need more time because they have delayed processing. So you cannot do rapid response with autistic people. It discriminates against the autistic person. Imperatives are for directing rather than relating. They put autistic people on the spot and often make them anxious. When others are primarily imperative, we wish to avoid them. People with autism feel anxious about relating to begin with. When we question primarily prompting and directing, they wish to escape the interaction. Imperative language tends to push them away rather than inviting relating. They shut down or become oppositional. And so at that point, that's when they are taught in the Florida Bar CLEs and by the Florida Supreme Court that the autistic person, because they're not getting this accommodation from the Florida judge, is becoming oppositional. Therefore, they are put on the autistic segregation vexatious list. Because if they're oppositional, which is being created by the judge's illegal discrimination, autism discrimination against the autistic litigant, then the judge takes the damage the court is causing as the reason to put the autistic person on the segregated autism vexatious list. What they don't understand is their act of discriminating is the eligibility criteria that's putting the autistic person on the autism vexatious list. Let's take another analogy. Recently, the Department of Justice went after a whole bunch of Florida schools because they were using seclusion and restraint at very high rates on autistic people. Why? Because they don't have any autism skills. Because they don't have any autism training. That's adequate, at least. And so, therefore, they resort to this neurotypical bashing, punitive bashing method of dealing with the autistic person. Bash the person, punish the person, seclude them, restrain. Why? Because the school officials, the court officials, they lack the skill because they lack the autistic training. That's why. So it's a wrong response. It's a discrimination response. It's school abuse. It's court abuse toward autistic people. Why? Why do they get away with it? Because the court system in Florida is not requiring mandatory autism spectrum educational training and mandatory Title II American with Disabilities Act training of every single Florida judge and justice. That's why. Because they don't understand what they don't understand because they lack the training, so they resort to abusive measures that discriminate against autistic people. So let's continue. On the other hand, declarative language is any statements not meant to produce a specific response, not prompting, directing, or instructing. These include sharing your thoughts, feelings, and ideas about something, describing events, sharing experiences and knowledge, and other interactions that are non-demanding. This language is non-directive and does not produce performance anxiety. For example, I like the color blue does not require a response back, but often invites the other to also share. I also like the color blue, or I like red. Communicating to relate and share, not direct and instruct. Autistic people feel freer to relate when they are not being questioned, prompted, and directed to communicate. When two neurotypical people are relating, here comes the discrimination. When two neurotypical people are relating, their interactions tend to be 80% declarative language and 20% imperative language. They spend more time sharing thoughts, feelings, and perspectives than questioning, prompting, and directing. On the other hand, when neurotypical and autistics are relating, it tends to be more the opposite, about 80% imperative and 20% declarative. Since the autistic person tends to struggle with conversing, the neurotypical person, and in this case the Florida judges, will try to maintain the interaction by asking more questions to draw a response from the person. Unfortunately, the very language that the neurotypical judges are using to help the autistic person interact is the language that makes autistic people the most anxious. Instead of making it easier to relate, neurotypical is making it harder. Right there also is an equal protection violation. So if the neurotypical Florida judges, when they communicate with neurotypical litigants, are using about 80% declarative language and 20% imperative language. But all of a sudden, when they're confronted with an autistic litigant, they're change everything upside down. And they don't deal the same way with the autistic person as the neurotypical litigant. They change everything and become far more harsh and controlling. Control that autistic person. Why? Because they lack the skill on how to handle and deal with autistic people in the Florida courts. And so they just all of a sudden resort to about 80% imperative language and 20% declarative language. So look at this. Neurotypical, 80% declarative, 20% imperative. Versus the opposite with autistic people, 80% imperative and 20% declarative. That's differential treatment, and it's a violation of the Equal Protection Clause of the U.S. Constitution. And these Florida judges are doing this because they don't have the skills. They are failing autism. No one can have, in the public, can have confidence in a court system like that because they're abusing autistic people. They don't want to see it. They want to ignore it. They claim they're the learned profession. Well, that's just like nonsense because they're failing autism and they're violating multiple constitutional rights when the person is autistic. And the primary reason for it is they did a faulty, defective implementation of the enforceability of Title II of the ADA in the Florida state court system. And they lack autism spectrum training. You give everything to the ADA coordinator, and she's going to go abracadabra. I'm going to wave my magic wand and hope that the judge, wishful thinking that the judge will accommodate the autistic person in the judge's interaction with the autistic person, which is one of the accommodations that they need to do. It doesn't work that way. It's a Title II ADA violation on its face on the Florida state court system when the person is autistic. I know this because I have lots of experience with these people and their abuse of me as an autistic person. And so what do they need to be doing? What do these Florida judges need to be doing to accommodate autistic litigants that they're not doing? And this comes from the judge, not the ADA coordinator. Unless the ADA coordinator, they think they're going to sit there and hold the judge's hand and do the work of the judge because the judge can't do it. Well, most of Bill Nason's experience with autistic people is that autistic people freeze up with anxiety when neurotypicals question and prompt them, but relax when everything is rephrased in declarative language. When Bill Nason relates with declarative language, shares experiences instead of prompting and directing, autistic people relax and relate a lot easier. Unfortunately, most teaching techniques commonly used with autistic people are mostly imperative. Neurotypical people prompt, direct, instruct, and pressure performance from autistic people. This approach not only inhibits learning, but it also discourages relating, learning to rephrase what you say, to share your thoughts, feelings, and perspectives rather than prompting and directing. The neurotypical in this event would see the autistic person begin to open, relate, and share more. Learn to rephrase your imperative statements, directives into declarative, non-directive statements, and watch the autistic person respond. Using declarative language allows the autistic person to respond in their own way. It promotes relating by sharing thoughts, feelings, and perspectives. It also takes the pressure off, reducing anxiety, and makes communicating easier. Sharing the neurotypical's thoughts, feelings, and experiences promotes perspective taking. This allows the autistic person to relax and pattern their own thoughts and responses. And here are types of declaratives. So they give examples and how to reword neurotypical statements from imperatives to declaratives. And so in some, this is some of everything that's going wrong with the Florida state court system. This is why, as an autistic person, if I sued the Florida State Court System, the 8th Judicial Circuit of Florida, and the Florida Supreme Court for violating Title II of the American with Disabilities Act of my rights, due process and equal protection rights, under Title II of the ADA, this is why they would lose on summary judgment. Why? Well, because the Florida Supreme Court made its confess-all declaration against interest, that the failure to reasonably accommodate the disabled person violates the Due Process Clause of the U.S. Constitution. Well, what happens when they violate the Due Process Clause? It results in a void judgment. There is lots of Florida case law on that. United States Supreme Court case law. It results in a void judgment. And a void judgment is supposedly has no force and effect. It's a nullity. And if you bring a post-judgment motion to set aside, which is the motion I brought to the Honorable Monica J. Brasington, that she complained, you filed it at 10:47 and the hearing's at 11. Oh my God, I can't read fast enough. I didn't read your motion. But I'm denying it because I'm the judge and I can sign yours. Well, that's judicial misconduct, okay? And if I move to set aside a void judgment for contravening the Due Process Clause, which the Florida Supreme Court's own Gabriel v. State admits she did, given everything I've laid out in this video, she failed to reasonably accommodate my disabilities. She violated Title II of the ADA in those other two cases, put me on the autism segregation vexatious list by violating due process, which results in a void judgment according to basically all the case law. And so this is the consequence of what happens when a person is autistic and the courts are not very clued in on how to handle autistic people in the courts. It's like results in a total arbitrary and capricious experience. Irrational, lacks integrity. The public can't believe in the court system anymore. And it's crazy. And they continue to do it. And the more an autistic person such as myself raises these issues, complains, and I graduated law school. I passed the California bar exam. That nobody in the Florida courts have ever proven that I don't have the knowledge I proved I had. All they do is say absurd things about my being autistic and what they think they know about autistic people, which is just nothing. And so there's one more thing that I have to say about this, and that is, in Pennsylvania, the state of Pennsylvania has a judge's autism bench book. It was apparently sponsored by the PennsylvaniaAutism.org, and it is an entire bench book for judges to use when they have an autistic litigant. It's a reference guide, and they've reprinted it here. Now, I had a PDF of it too. So, here's the PDF. This is the bench book. This is a judge's guide to autism. It's a PDF document, 46 pages, that Pennsylvania State Court judges can have right on the bench at their fingertips, carry around with them. When they get an autistic litigant, it tells them all sorts of things. What is autism spectrum disorder, diagnosis, supports, evidence-based treatment, supports for the courtroom, data, resources, facts, autism services, education, resources, and training is a statewide initiative. Okay, so they're getting autism training, unlike Florida. The Judge's Guide to Autism is a resource for judges that come in contact with individuals on the autism spectrum who have contact with the court system. And so we can compare this to Florida. There is no Judge's Autism bench book. They have a judge's foreclosure bench book, but they don't have any judge's autism bench book. And so even right there, you could show a federal court that, you know, you have the Florida Supreme Court giving a public records response that at least up until 2021, no judges in Florida had autism spectrum educational training. And you could show that Pennsylvania has a judge's handbook, but Florida's done diddly squat to even do that in their courts. Then all they do in the Florida courts is some brainy court counsel must have advised them that they could cut their budget by implementing Title II of the ADA and the reasonable accommodations by just don't spend any money on judicial education, give it all to the ADA coordinator who has a conflict of interest to cut court budgets. And she will provide, or he will provide, the accommodation. But being autistic is a special type of disability. It's not like any other disability. And we have to remember that these Florida court people, they don't invite autistic people to their parties. What that means is they are almost 100% homogeneously neurotypical. They do not consult autistic individuals on their court rules and policies. They don't consult disability organizations, disabled people, or autism organizations on their court rules and policies. So they really don't know what they're doing. And so then they think all disabilities are alike. So if somebody were deaf, if somebody were blind, well, you could just give that to the ADA coordinator and she could provide Braille, or she could provide cartwheel time, and they're not even providing the transcript. So even if they think in Florida, well, give it to the ADA coordinator, she can provide Braille, she can provide cartwheel time, she is not the judge's brain. She doesn't have the judge's JD and bar pass, legal education. She is not the judge's mouth. So the ADA coordinator cannot give the autistic declarative imperative accommodation in the social interaction between the autistic person and the judge as it's happening and unfolding in real time in the courtroom. And for that reason, the Florida state court system is in complete and wholesale violation of Title II of the American with Disabilities Act on an ongoing and continuing basis, and repeated violations, and continues to do so, respecting autistic disabled people like me, and me in particular. So, I went through this video because I'm trying to make life better for autistic people, especially in Florida, and educate about being autistic and some of the things we go through, some of the abuse that we receive in the Florida court system, why it's happening, why we're misunderstood and misinterpreted, and it's just utter, like, chaos in the Florida state court system. Now, Florida sheriffs and law enforcement are mandated by statute to receive, at a certain interval of frequency, educational training in autism spectrum disorders. So what you have is you kind of have a mockery situation with these Florida courts. The public is mocking them because the public, families with autistic people who are autistic, they know that the court's bailiff is more able to adjudicate an autistic person's case and maybe get it right as far as the person being autistic, because they're mandated to have the autism training, than any of the Florida judges or justices. I'm saying how it is. I'm explaining my civil rights violations at the hands of the Florida state court system. Why they're happening, how they're happening. It's an attitudinal discrimination basis as well, because they don't want to change things. They certainly don't want to spend the money on educating everyone in the courts, and especially the judges. It's the fact, though, that the state of Florida has mandated the law enforcement, that's the court bailiffs, to receive autism training, and not the judges. That's what sets up the mockery. Not me, not anything I say. I'm a victim. I'm a victim of this court abuse, because I go into the court, I do all the legal research the way I was instructed to do it in law school. I apply a lot of the facts the way passing the bar exam certifies I'm educationally trained with a Juris Doctor to do so. I go beyond that. I consult other licensed Florida bar members who tell me I have a valid claim. I have law enforcement officers telling me I have a valid claim, I need to sue. I go into the court, that's frivolous, that's vexatious, that's delusional, that's nonsensical. Anytime I talk about being autistic. Well, you know what? Autistic lived experience and neurotypical lived experience are two entirely different world experiences. We don't have the same nervous system. We don't have the same sensory experiences. And each one is equally valid. That's not how it works. We are all supposed to be treated equally, and autistic people are supposed to be understood, not misinterpreted. And you're punishing people who are innocent, who only have good intentions going in, and then we get misunderstood. And whammo! We're punished. We're smacked. We're smacked down. We're told we're bad, we're broken. Well, we don't think we're bad. You're imposing labels on us that does not portray who we think we are. And as my husband caught last night on the radio, a podcast being put on by the University of Florida about late diagnosed autistic people and what the late diagnosis means to us, how it gives us a perspective of how we've been mistreated our entire lives, and on the court systems. Well, you know, there's other people in Florida saying what I'm saying. But I did this video because I think that more attention needs to be given to all of this. I think the Florida court system's way behind the 8 ball. I think they're very wrong in how they're dealing with this. Autistic people in the courts. Autistic people are now at least 1 in 36 people in Florida. And this is just wrong. It's wrong. And I'm going to stand up for one person and say so. And I hope there's other autistic people who also stand up and say so. We don't deserve this mistreatment. We don't deserve to have our lives ruined by these judicial officers that have 0 autism spectrum educational training. That's my video for today. If you like my videos, if you're learning something, please hit the subscribe button and ring the bell, and you'll be notified of my future videos. Thank you for watching.